Good afternoon, everyone. Welcome to our first and last podcast of the semester. My name is Eric Pinzon, and today I'm here with my co-host,
Melanie Moya, and our editor, Laura Almanza.
Today we'll be talking about the book How to Interpret the Constitution by Cass Sunstein. First of all, we're going to talk about a little bit about the book, and then we'll dive into the main ideas and main concepts of the book. And from there, we'll have a little conclusion at the end just to give you an idea of what it's all about and why you should read it. To start off, we'll be talking about the author Cass R. Sunstein. He is the author of How to Interpret the Constitution, and he's a highly regarded legal scholar and professor at Harvard University. Sunstein has a wealth of experience, including founding a program on behavioral economics and public policy at Harvard Law, and served as a senior counselor in the U.S. Department of Homeland Security. He clerked for Supreme Court Justice Thurgood Marshall, gaining firsthand insight into high-level judicial decision-making. Sunstein has also testified before Congress, advising organizations like the United Nations, and authored numerous articles and books on topics range from regulation policy to constitutional law. His extensive credentials underscore his authority on interpreting the Constitution, encouraging readers to reflect on their values and political engagement.
Cass R. Sunstein's book has 7 sections. The introduction, where he begins with background information readers need for the book, like his 2 goals, fixed points, and reflective equilibrium, and a for record section. The first chapter is on theories of interpretation. The second and third chapter explain why there's no right interpretation that perfectly fits every scenario, and that everyone will have a variety. Chapter 4 argues how fixed points have several levels of importance and are absolutely necessary to each person's choice of interpretation. Chapter 5 focuses on traditionalism, its appeal to the masses, and how it should be rejected as a dominating interpretation. Chapter 6 is personal to the author. Contrary to the overwhelming neutrality he maintained throughout the book, it gives his view on what he believes the Constitution should and shouldn't allow.
There is no single correct way to interpret the Constitution. Sunstein introduces and critiques multiple perspectives, including textualism, originalism, traditionalism, and moral readings. He provides insight into how these theories influence judicial decisions, especially in landmark Supreme Court cases. By highlighting the complexity and flexibility of constitutional interpretation, the book encourages readers to reflect on their own views and engage critically with the subject.
In How to Interpret the Constitution, Cass Sunstein addresses the challenges of balancing the Constitution's original meaning with modern societal demands. He advocates for viewing it as a living document, anchored by enduring principles like liberty, equality, and fairness, what he calls fixed points. While approaches like originalism emphasize sticking to the text's original intent for predictability, Sunstein critiques this inflexibility for failing to address contemporary issues like LGBTQ rights. Similarly, he critiques traditionalism for its potential to perpetrate harmful customs, like those tied to slavery or segregation. Sunstein argues for a flexible interpretation that respects the Constitution's core values while evolving to meet modern needs, ensuring it remains both stable and just.
Cass Sunstein supports his arguments with historical examples, landmark cases, and philosophical readings. To critique originalism, he highlights cases like Brown v. Board of Education, where segregation was ruled unconstitutional despite the 14th Amendment's framers not explicitly addressing segregation in schools.
Similarly, he critiques traditionalism by citing practices like slavery and segregation, which through traditional violated principles of liberty and equality. While traditions can provide guidance, they must be critically examined to ensure alignment with contemporary values.
Sunstein proposes judicial minimalism and pragmatism as alternative approaches. Judicial minimalism encourages incremental, narrow decisions to preserve democratic processes, while pragmatism focuses on real-world consequences and adapting to societal progress. This dynamic approach ensures the Constitution evolves while staying true to its foundational principles.
To advocate for pragmatism, Sunstein references Obergefell v. Hodges, where the recognition of same-sex marriage reflected evolving societal values like dignity. Sunstein underscores the Constitution was designed as a flexible framework, not a rigid set of rules. By focusing on enduring principles while embracing pragmatic evolution, he argues, courts can ensure its continued relevance and justice.
Sunstein's concept of provisional fixed points emphasizes the importance of moral and political principles which guide individuals in their decision-making. For example, beliefs like murder is wrong or lying is wrong are seen as firm but flexible based on societal evolution. In today's political climate, people vote based on these principles, often disregarding candidates who contradict them. This is particularly relevant in authoritarian regimes, where holding onto fixed moral points helps resist oppression and protect democracy.
Issues like digital privacy, gender equality, and climate change are not mentioned in the Constitution, but are shaped by the people through courts and representatives. Sunstein points out how Supreme Court rulings evolve with public norms, as seen in landmark cases like the overturning of Roe v. Wade.
Sunstein critiques originalism and traditionalism for their limitations in addressing modern issues. Originalism, which interprets the Constitution strictly based on its 18th century meaning, fails to account for contemporary issues such as same sex marriage, civil rights, and environmental protection. Similarly, traditionalists adhere to outdated societal practices that can perpetuate injustice. Sunstein advocates for pragmatism, where judges consider the broader societal impact of their decisions, ensuring laws align with modern values and goals.
Sunstein argues for a mixed approach to constitutional interpretation. No single theory can adequately sustain democracy. A variety of interpretive methods is necessary to ensure that the Constitution remains relevant and responsive to societal progress.
Sunstein's How to Interpret the Constitution connects directly to key themes in our American federal government course, particularly the interpretation of the Constitution, the role of the judiciary branch, and the protection of rights within a democracy. The book encourages readers to question their values and political beliefs, aligning with the course's focus on constitutional law, the implications of court rulings, and the ongoing importance of critiquing and participating in the democratic process.
Sunstein highlights the evolving nature of constitutional interpretation, which ties to our studies of how public opinion, political alignments, and citizen engagement shapes government policies. He also emphasizes that the Constitution's strengths and flaws, reflecting on its adaptability over time, are important themes in understanding the balance between stability and change in democratic systems.
Additionally, Sunstein's critique of originalism and traditionalism relate to concepts of separation of powers and judicial review. Seen in landmark cases like Marbury v. Madison, he advocates for judicial minimalism, warning against overreach by the judiciary branch, which aligns with our course discussion of checks and balances. Sunstein focuses on civil rights and liberties, echoing the course's emphasis on how courts have protected minority rights and upheld democratic principles. Ultimately, the book illustrates how constitutional interpretation is shaped by public input, evolving norms, and the need for ongoing advocacy.
Sunstein emphasizes how diversity of opinion and the evolving nature of rights are central to the democratic process, which allows citizens to shape policies to fit current needs that they may want. This reflects the course's discussions on how the Constitution adapts over time, with individuals' interpretation helping overcome injustices and sparks of necessary change.
The book is valuable for its comprehensive exploration of constitutional interpretation theories. Sunstein introduces key legal thinkers and their theories, allowing readers to understand different judicial approaches. His concept of reflective equilibrium and the idea of fixed points offer a middle ground approach, helping to balance abstract legal theories with practical decision making. The open-ended nature of the book encourages critical thinking and personal reflection on constitutional law.
A potential flaw is the book's lack of a clear, definite stance on how the Constitution should be interpreted. While this open approach fosters critical thinking, it might leave readers looking for concrete answers. Sunstein's exploration of various theories without offering a final resolution can be seen as both a strength and a weakness, depending on the reader's perspective.
Sunstein's book is an excellent resource for those interested in constitutional law and judicial reasoning. It provides a deep dive into the different legal theories that shape Supreme Court decisions, that encourages readers to think critically about the Constitution and its interpretation. While it may not offer simple answers, it equips readers with the tools to engage thoughtfully with complex constitutional issues.